नमस्कार दोस्तों, हमारे शॉर्ट हैंड लैब प्रयागराज चैनल पे आप सबका बहुत बहुत स्वागत है। मैं आपको लीगल डिक्टेशन प्रोवाइड करने जा रहा हूँ जिसकी स्पीड होगी 90 to 100 वर्ड्स पर मिनट। 622 वर्ड की डिक्टेशन है। आप लोग डिक्टेशन के लिए रेडी हो जाएं। स्टार्ट। इन व्यू ऑफ द 3 जज डिसीजन ऑफ द सुप्रीम कोर्ट referred to above, it is apparent that the standard, inter alia, for cow milk has been prescribed by a committee known as the Central Committee for Food Standard, constituted by the central government in consonance with the provisions of Section 3 of the Act and subclause under bracket first dash A bracket close read with subclauses under bracket L bracket close and under bracket M bracket close of Section 2 thereof clearly lay down that an article of food shall be deemed to be adulterated if the quality or purity of the article falls below the prescribed minimum standard or its constituents are present in quantities and within the prescribed limits of variability, whether the same renders it injurious to health or not. Full stop, paragraph. I find that the sample is adulterated and the courts below committed no illegality in convicting the accused and awarding sentence. Full stop, paragraph. In view of the facts and circumstances of the case that the alleged adulteration was made in the year 1981, it would not be proper to send the accused to jail after such a long time, more so when he had served out at least few days sentence after his conviction. Full stop. The Supreme Court in State of Odisha versus K. Rajeshwar Rao, under bracket 1992 bracket close, first SCC 365, altered the sentence of imprisonment to sentence of fine on the ground that 15 years had passed by from the date of offence, and at this distance of time, the ends of justice may not be served by sending the respondent to imprisonment, more so when he has undergone all these years the agony of the prosecution. Full stop, paragraph. The offence in the case before the Supreme Court had occurred on March 13, 1976, before the amending act came into force. Full stop. The Supreme Court observed that under the unamended act, it was not mandatory to impose the minimum sentence. Full stop. This decision, therefore, is not applicable to the offences which occurred after the amending act came into force. Full stop. Since the legislation has done away with the discretion of the courts to award either sentence of imprisonment or fine and minimum sentence has been prescribed, the courts have been left with no discretion but to award minimum or any sentence up to maximum limit prescribed. Full stop. In my opinion, if, the legislation requires that on an offence being proved, at least minimum sentence of imprisonment has to be awarded, and the courts cannot overlook the legislative mandate and award sentence of fine only though on equity, it may feel justified to take lenient view. Full stop. However, courts can convert sentence of rigorous imprisonment into sentence of simple imprisonment. Full stop, paragraph. Though the courts have got no power to refuse to award minimum sentence of imprisonment, yet under clause under bracket D bracket close of section 433 of Code of Criminal Procedure, the appropriate government is empowered to commute the sentence of simple imprisonment and to impose fine. Full stop, paragraph. It is open to state government to take lenient view considering the nature of the offence and circumstances, especially the sentence awarded long before, comma, could not be implemented on account of delayed disposal of revision, comma, or appeal may commute the sentence, full stop. In view of this legal position, comma, the Supreme Court in N. Sukumaran Nair versus Food Inspector, comma, Mavelikara, comma, under bracket 1997, bracket close, 9 SCC 101, comma, considering the delayed disposal, found the case appropriate for commutation of sentence and directed the appellant to deposit in the trial court a sum of rupees 6,000 as fine in commutation of the sentence of 6 months simple imprisonment, comma, within a period of 6 weeks, and intimate to the appropriate government that such fine has been deposited, full stop. On deposit of such fine, comma, the Supreme Court observed that the state government may formalize the matter by passing appropriate orders under clause under bracket D, bracket close, of section 433 of the Code of Criminal Procedure. Full stop. Thank you so much.